question. I'd like to reserve the rest of my time for rebuttal.
May it please the court. I'm Kenneth Trent. I represent the appellee herein, Jefferson D'Souza.
Mr. Trent, why aren't they entitled to an evidentiary hearing? Getting past this excessiveness of two motions, why aren't they entitled under the rules to an evidentiary hearing if, and I'm not getting to the issue of whether or not the pleadings had culpable grounds, why aren't they entitled to one?
Because the case law speaks of the entitlement to an evidentiary hearing as a right of the moving party in terms of whether, if they do raise a colorable claim of entitlement to relief, then the moving party is entitled to an evidentiary hearing.
No, but the purpose of that is, it's the object of 1.540 is the moving party has an obligation to prove that there was fraud. And so what the rule's purpose and the way the rule works is that if you raise the issue, if it's colorable, then the court is obligated to give you an evidentiary hearing to prove it and give the other side the chance to rebut it. If it's not colorable, you don't get an evidentiary hearing and it's dismissed. So my question to you is, even if it were colorable what you raised, which I've got a question, why aren't they entitled to it? Why didn't the court err by not having an evidentiary hearing?
Particularly when they're conflicting affidavits under Venetian salami, when you have that, you should have a hearing.
Well, first of all, it's because both affidavits emanated from the same people. I mean, if you look at this record,
What case do you say that we disregard affidavits if they emanate from the same people?
well, I don't have a case. This is an unusual case, Your Honor. But I do want to emphasize, Your Honor, that Justice Suarez.
No, Judge,
okay.
Judge, don't
Judge
elevate
Suarez.
me yet, okay?
Yeah, well, I'm just hoping for justice. But at any rate,
We
the
don't
case.
deal with justice. We deal with the law.
I'll leave that one alone. But Dynasty Express is a case, and it says specifically, the party asserting the fraud is entitled to an evidentiary hearing on the issue.
Right.
I don't see
anything. If you raise a colorable issue in your pleadings, then you're entitled to an evidentiary hearing to determine whether or not there is fraud. But that's what all the cases stand for.
Right.
So, I mean, the point I'm trying to make is, even if your pleadings were colorable, why didn't the court err in not giving an evidentiary hearing? I mean, how can we sustain this if the court's obligated to give an evidentiary hearing if it didn't give one?
Well, I think you could easily just go by the exact language of the case law, which speaks of that evidentiary hearing as an entitlement or a right of the moving party.
That's right.
When you have a case like this where it's the non-moving party who's saying, well, wait, we want an evidentiary hearing.
But you're missing the point of 1.540 and the way it works. The object of 1.540 when you're alleging fraud is you're alleging fraud against the other party. The other party has a right to defend against that. So it's two steps. Your pleadings have to state to the judge, we've got colorable basis that there was fraud. And if the judge looks at it and he says, you're right, based on your pleadings, I see where you do have a colorable basis. So other party, I'm going to give you an evidentiary hearing to now prove to me why you didn't commit fraud on this court. So it's a two-pronged step. And the court here, the judge here, never gave the second prong of the requirement, which was an evidentiary hearing.
And he explained his reasoning in not doing so, Your Honor.
When was an evidentiary hearing requested?
That's a pretty good question. I don't believe it was requested at all until the motion for rehearing that was brought up, that was filed by the appellant.
You said that was pretty good. Ready for a good question now?
Sure.
This is a 1.540 motion, right?
Yes, sir.
Under what section of 1.540 are you traveling?
1.540B3 primarily.
B3 or A3? B3, yeah,
B3.
right, B3. That's where there needs to be fraud. You're alleging fraud. In this case, there was a complaint filed, a motion for summary judgment. Did your clients contest the motion?
I believe According to the record, I was not counsel at that time. They tried to
No.
represent themselves pro se, but according to the
The answer
record,
is no.
there was a motion to dismiss filed, but that's all prior to.
They allege.
And they did not contest the entry of the final judgment, right?
Well, I'm not sure what Your Honor means by contest. Did they show up at the
Where-
hearing and argue or file affidavits in opposition? No.
But they also, in their motion to dismiss, claimed that the plaintiff had no standing, correct?
Yes, but,
Which is basically what this whole case is about, right?
well,
I mean, you're saying basically that Freddie Mac is not the proper plaintiff to bring this action, that they really owe the mortgage to somebody else?
no, Your Honor, that's really not what we're saying. While what we're saying does address standing, just like.
You're arguing fraud.
Right, correct.
Under
More
B
particularly-
3 is the fraud provision.
Okay.
What is, we had a final summary judgment, there was no appeal. There, in this particular case, unlike the last one, we're within the 1 year period, so you can move under B 3. What's the fraud?
The fraud was-
What went wrong, briefly stated, summarily stated?
As stated by the court in the appendix to the record on appeal, which was the hearing on November 22nd, 2010, on the motion for rehearing, which was filed by the appellant. The court said on page 7, because counsel is correct in terms of what he used, in other words, what I used to argue fraud, it was your affidavit that was used and your initial pleadings that was used that basically establishes the fraud. And this goes to Judge Suarez.
What was the fraud, counsel?
The fraud
What was the fraud? Just tell me what the fraud is. Maybe somebody was correct, maybe somebody wasn't. We'll figure that out. But what is the fraud in this case?
The fraud was obtaining summary judgment in favor of Aurora Loan Services, based on Aurora Loan Services affidavit saying that Aurora Loan Services owns the note and mortgage. That is the affidavit filed, affidavit of indebtedness, and that was after the appellant, or maybe it was Aurora, it's hard to tell, had filed an assignment, taking the ownership of the loan away from Aurora and transferring it to Freddie
The
Mac.
fraud, as I understand it, is, just as you said, that Aurora moved for the summary judgment, and then between the time of the summary judgment motion and the time of the hearing on the final judgment, Freddie Mac was substituted. Is that,
Right.
am I articulating your position correctly?
Yes, Your Honor, you are. But
What is fraudulent about that? It was all on the table.
the fact that they continued to travel on the affidavit of indebtedness, which said that Aurora Loan Services owned the note and mortgage, meanwhile, obtaining the final judgment in favor of Freddie Mac. You see, they can't have it both ways. It's one or the other, and they are continuing to travel on
And
an affidavit that they haven't.
it was the other, and there was no appeal from it, right?
I could see that if Freddie Mac came in here and they misrepresented that they own the mortgage, and Aurora would have something to complain about. But Mr. De Souza has not paid anybody. He hasn't paid Aurora, hasn't paid Freddie Mac, he hasn't paid Mars, he hasn't paid First Mangus. Nobody has been paid, correct?
Correct, Your Honor, but I'd
Okay,
love to
I can
respond.
see if the owner has been paying the wrong mortgage company, and somehow the wrong person files suit and caused a lot of litigation, that would be fraudulent. But here we have, everything was done above board, like Judge Shepard says. I don't understand what the client has to complain about, other than he wants to live a few more months for free in that property.
Your Honor, I understand that you may have a concern about my client getting a free house. I mean, I've run across that several times. But I would like to emphasize that the whole purpose of the standing requirement, which is the material element to which this fraud was directed, is to prevent a plaintiff from getting a free house. If this court is going to allow, and if any court is going to allow a plaintiff who cannot prove its standing through competent, substantial, authenticated evidence to obtain a judgment against the homeowner, then that is
Aurora had standing at the time that it filed the complaint.
right. Apparently, according to the assignments that were filed, but the
Well,
assignments.
that's all we have are the assignments, and they had standing. They owned the note and mortgage at the time they filed the complaint. That's standing, that's subject matter jurisdiction, correct?
I agree.
And standing because Aurora had the note.
Right. But for Aurora to transfer the note to Freddie Mac and then to continue before the court and to get a judgment in its own favor.
Freddie Mac got the judgment based upon whatever affidavits existed, maybe signed by Aurora, right? The facts didn't change.
Well, they did change as to who was the owner of the note.
It was all above board.
Not
Your burden here is to there has to be a gross abuse of discretion, right?
Yes, Your Honor.
If you were the appellant, it would have to be a gross abuse of discretion, I guess.
Yeah.
Maybe that's their burden.
They have to show that there was a gross abuse.
He looks insane.
For this court to overturn the lower court's ruling, especially since this was a determination of fraud. And the determination of fraud is generally considered to be uniquely within the province of the trial court. This was the judge who said, you came before me and you represented that you had standing, and as of that time, it was a lie.
Let me read you something from the Paul versus Wells Fargo case, which you cite to justify having the second bite of the apple with the second motion to vacate. It says, Mrs. Paul first argued that Wells Fargo lacked standing to foreclose on a note and mortgage issued by Washington Mutual. The trial court properly rejected this argument. Wells Fargo's possession of the original note, endorsed in blank, is sufficient under Florida's Uniform Commercial Code to establish that it was the lawful holder of the note entitled to enforce its terms. That's precisely what we have here.
I don't believe there's ever been any. First of all, it's never been an issue in the case whether or not there was an endorsement. I believe that the plaintiff, in this case now, I guess.
They possessed the original, correct?
That I'm not sure, to be honest with the court, but I know they filed assignments at the end of the case, which on their face were not above board, as Judge Shepard suggested, because they were both signed by the same person who is apparently a representative of Aurora. This gentleman, and that is was in our motion, and I believe it's addressed in our brief. This person signed an assignment first from the original lender to Aurora Loan Services, and this was right before summary judgment was entered. And the same individual signed the next assignment, which transferred it from Aurora Loan Services purportedly to Freddie Mac.
Did you take any discovery to find out why that occurred?
Well, no.
All we have are the two documents showing that, correct?
Correct, Your Honor, but the signatures are not even the same. And
did you file an affidavit stating?
No, Your Honor, we relied on their affidavits and their proof. That's another reason that not only did we raise it.
Signatures are not the same. You need to prove that somehow. You could take Mr. Schultz's deposition and ask him. Maybe he would have admitted it.
But we never got that far because the court found the first grounds, which had to do with traveling on, an affidavit of indebtedness saying that Aurora is the owner of the note and mortgage when obtaining final judgment, even though in the interim there had been an assignment filed by the plaintiff saying that Freddie Mac was now the owner. The court found that to be fraudulent, and it was a misrepresentation.
Let me ask you a question. I understand your argument. Every case that I've pulled up in researching your case having to do with this question of standing in this type of situation, I haven't come across one that says it's fraud. Can you point me to a case that says in this situation like we have here, we're dealing with foreclosure, somebody files it, there's an assignment, you go through the whole process. Can you point me to a case that says that's fraud?
I'm not sure I understand your question, but it says what is fraud?
That lack of standing in this type of situation is fraud on the court. Can you point me to a case that says it's fraud? It may be lack of standing. You may have a lack of standing argument. But my question to you is, can you point me, I could not find one case that said it was fraud.
When an affidavit or something is filed that attests to a state of facts that is not actually true?
Don't generalize it. I'm talking about in this situation where you have a mortgage company, or a company goes in, they file a foreclosure, they say, they verify, we've had argument on verification today, they verify that they own it. Then as the process goes on, there's an assignment to another mortgage company. That assignment is filed. You have a summary judgment, and it's completed, and then the court grants it. There may be a question of standing, I even doubt that, but can you point me to one case, and I'll repeat what I said, I could not find one case in the state of Florida that said that this was fraud on the court. Maybe lack of standing, putting that aside. Can you point me to one case that says it's fraud?
Well, not with the scenario that you've outlined, Your Honor,
But is that the scenario we have here?
no, because the scenario we have here is where there are affidavits filed which are countered by other filings from the same party, and yet that party goes ahead and obtains summary judgment. In other words, they've contradicted themselves on the issue of standing with sworn statements, and then tried to disregard one of those and obtain a judgment in
Okay.
reliance.
I understand what
We're
you're
going
saying.
around in circles. I
There
think
are cases
in
where,
conclusion,
well, I would just say that, I mean, obviously, the standards are in our favor. There's fraud determination by the trial court, which is difficult to disturb, plus, the gross abuse of discretion. But the final point that I would make is, there has been fraud committed all over this country, and that's why we have these attorney general actions.
we're
Like,
trying one case at a time, and in
Okay.
conclusion, you want us to affirm. Thank you.
absolutely, thank you.
Thank you, counsel.